Okay, guys, welcome to week 4 and chapter 4. We're going to talk about criminal law. Specifically, we're going to talk about substance and procedure. Diving into this lecture, we're going to discuss at a high level, as always, the differences between criminal law and procedural law. We'll dive into substantive criminal law. We'll talk about where our criminal law comes from. We're going to talk about the classification of crime. We're going to talk about what the elements of a crime are. What are some standard legal defenses for that? And when we talk about criminal procedure in the Constitution, specifically, we're talking about those things that the criminal justice system are required to do. And then we will finish with due process. There are two different categories of law that the criminal justice system finds itself in: criminal law and what's often referred to as civil law, but in other places is known as tort law. In both circumstances, the goal of both sets of code or statute is to control behavior, to control public behavior. Um, Crimes are public offenses, and torts are civil or private wrongdoings. Another way to look at that is when we have committed a societal crime or a status crime. It's something that has the potential to harm or displease society as a whole. A tort is one where we didn't necessarily physically hurt someone, but we did something they believe to be wrong, and that's what needs to be heard. Both types have the ability, both civil and criminal law have the ability to impose sanctions, but those sanctions are different depending on the course of action that's taken. For example, in civil law or tort law, really the only sanction that's available is monetary damages. Someone's been sued and asking for a specific amount of money. In criminal law, those sanctions can result in incarceration and, in the worst case scenarios, the death penalty. Common areas of legal action for either criminal or civil law could be personal assault or control of white collar offenses like environmental pollution. In criminal law, the right of enforcement belongs only to the state. In other words, only the government can bring an action in criminal law, while under civil law, any individual can file a complaint with the court. This is something that as law enforcement officers we encounter on a regular basis when we go to a call for service, or someone's made a complaint to the police department or the sheriff's office, and we show up and they say, I want to press charges against so-and-so. Lawfully, they are not entitled to do that. They can make a complaint to law enforcement, but it is only the government, through the state's attorney, who has the authority to bring a case before the court. Again, on the monetary side of things, damages can be paid to a victim, or often are paid to a victim in a tort case. They can also be paid in a criminal case, which is also known as restitution, or a fine that's been levied by the courts. In criminal law, fines will always go to the state, while restitution is paid back to the victim. In civil law, the person making the complaint, presuming they win their case, is the one who receives the compensation for that. The final point here is that some acts, including rape, assault, battery, corporate crimes, can see both criminal and civil actions. It will vary from one state to the next whether that is allowed or not. But in many cases, you could see someone criminally charged for rape, and you could see them sued for the same thing. Let's talk about substantive criminal law, and it's best to really consider the definitions of all the different types. Okay, so when we're talking about criminal law, we're talking about rules that define crimes, establish punishments, and mandate how the court system is supposed to, or the entire criminal justice system rather, is supposed to carry out the process of enforcing that specific law. Substantive law is more like our criminal code as we understand it today. It's a body of rules that declare what conduct is criminal and describes the punishment to be imposed for such conduct. In Kansas, that's primarily found in Kansas statutes under Chapter 21. Almost every one of our crimes is in Chapter 21 of our Kansas statutes and most of our guidebooks that we take in the field only carry chapters 21 or chapter 8, which is our traffic code, which is a nice little point to bring up. It won't matter for later, but it's just a nice little add-on, is the violation of traffic laws is not a crime. It's not defined as a crime. It's defined as simply a violation of traffic laws. Not that they're not enforced, not that there's not fines and penalties that are still applied, but it's not the same as a crime. Procedural law describes the methods that law enforcement and the criminal justice system must follow in order to conduct their business. Okay, so those are the rules that are created regarding when we have to request a warrant, how we can go about investigating some offenses, when we can and when we cannot make an arrest, and how trials are to be conducted, how evidence can be introduced at trial, and how sentencing of people who are convicted can occur. All of this is subject to review by an appellate court to primarily ensure that it's being conducted appropriately in the way in which the law set itself out. Anything that's not criminal, including tort, contract, personal property, maritime laws, and commercial laws, is all considered civil law. So anything that doesn't have a incarceration sanction attached to it would be considered civil law. Torts are simply the law of personal injury. So when we talk later about 1983 class action suits for wrongful death filed against a law enforcement officer, we're talking about tort law at that point. And then finally, public law is the branch of law that tells government how to act, how it can interact with the public, how government can interact with different agencies within the same government or with agencies of other governmental jurisdictions. It is the binding piece that defines what government can and cannot do. We won't spend much time there. So where does our criminal law come from? Well, particularly it comes in two places: from the United States Congress and from our state legislatures. For most of us that work at the local level, we only consider state criminal codes. We do not have the authority to enforce federal law, so it's not anything that we pay very much attention to. That's what federal agencies are for, not us. But for police departments, county sheriffs, and state police, predominantly we're concerned with the criminal code that's been created by the state legislature. Governments, both the United States Congress and the state legislature, are restrained by the Constitution. Specifically, the Constitution lays out that any criminal statute cannot be vague. It must be specifically defined. It prevents any person's specific status, such as race, gender, sexual orientation, from being a crime. It also prevents cruel and unusual punishment. We'll talk more about that later. And it prevents punitive action without a trial, meaning we can't simply send someone to prison without there being a trial. Some of you at this point may hold up and go, now, wait a minute. I have seen plenty of people sent to prison that never had a trial before. Just because the government must ensure that these rights are provided for does not mean that the defendant can't waive all of those rights. That's the advantage that plea bargaining provides, is if a defendant knows he's likely to be convicted, they can arrange for a plea bargain and gain a lesser sentence, which means they don't go to trial at all. Finally, the Constitution prevents or restricts any ex post facto laws, which means that if today we decided that drinking coffee was a felony, we could not then go back and charge anyone who drank coffee prior to today with a violation of that act. If drinking coffee was a misdemeanor and we changed it to a felony, we also could not go back and increase the penalties on those people who drank coffee as a misdemeanor before. Once the law is set and in place and lawfully enacted, then we can move forward. We cannot take it back in time. Classifying crime is also the responsibility of the legislature. In other words, it is not up to the criminal justice system to determine what actions are and are not felonious, and it's not our responsibility to determine if something's simply a misdemeanor. While we have broad discretion in many cases of whether to enforce a specific statute or not, we do not get to determine the classification of the offense. Felonies are crimes graver or more atrocious than those designated as misdemeanors. In other words, real harm has been done to someone for a crime to be a felony, or the potential for real harm has been done um, to someone for something to be a felony. Another good way to differentiate between felonies and misdemeanors, at least at the law enforcement level, is to understand that as the county sheriff, I may hold people charged with felonies in my jail, but only up and until after sentencing. If they're sentenced to prison, they cannot stay in my jail. The only long term incarcerated convicted offenders that I can have are those that have been charged with misdemeanors. So, in most cases, the longest you'll see someone held into a county jail is 12 months. There's always a lot of exceptions to that based on other legal precedents that doesn't matter necessarily today. But by and large, when you think of misdemeanor, think of county jail. When you think of a felony, think of our prison system. There are enshrined within legal code and within our Constitution specific hurdles that must be crossed, or specific things that must be identified in order for a crime to be proven. Those are called the elements of a crime. Um, they're centered primarily on the identification of the accused person and what the actual act was. They center largely on our legal Latin terms known as actus reus and mens rea. The accused engaged in the guilty act, specifically meaning we know who this person was and we know that this act occurred. Mens rea means that the accused person had the intent to commit that act. Other factors that we have to incorporate into the elements of a crime is the location of it. That's important because we have to be able to say that we know where that it occurred. And secondly, we have to be able to display that it was within our jurisdiction and our authority to investigate and act. Any injury, harm, or loss must be identified. It can sometimes be through negligence, but we need to be able to show that even though there wasn't the intent to commit the act, that offender understood that by negligently acting in that way, someone could be harmed. Ignorance is measured essentially in the same way. So, when we talk about the legal process, the one step, especially in law enforcement, believe it or not, that we consider on a regular basis is what could be considered legal defenses. In other words, if there's a valid defense for an act to occur, we have no action that we can take. So it's important. It's as important for us to understand this as it is for a defense attorney to be able to argue for their client. Two typical types of defenses are an excuse or a justification for the action to be taken. Excuse defenses are incorporated typically through duress. In other words, I was forced to act in this manner in order to prevent greater harm to myself or someone else, whether personally, financially, whatever the case may be. Insanity, a common defense that fails on a regular basis. But the argument is that at that point in time of the act, the defendant's state of mind prevented them from understanding that they were causing harm or violating the law. That is a common defense that we see in Kansas on a regular basis, where we see competency evaluations that typically fail, and it's usually just a delay tactic at this point in time. Age is a critical factor. We don't send children to prison. We don't criminally charge small children. The age limits will vary from one state to the next. The variance is from age 7 all the way up to age 14. It depends on the act, on what it is that specifically occurred, and how old the child is. Those are decisions that prosecutors make, not law enforcement officers. And then, of course, entrapment. This is law enforcement's use of traps, decoys, or specific deception in order to gain a violation of the law. These are very uncommon, though we're accused of it on a regular basis. It's very rare that you actually see a case of entrapment. Finally, justification is one that has gotten a lot of notoriety over the past 10 years because it has everything to do with self-defense. The stand your ground laws have, in every state, have come under great scrutiny because of different shootings that have occurred in different circumstances. But the law is clear. We have the right to protect ourselves. We have the right to protect someone else who's close to us. And if we are acting in order to prevent greater harm from occurring to either us or to someone else, we're not liable for a criminal event. Consent is always a tricky one. It does not always apply to rape, but that is the most common scenario, and we see in which consent becomes an argument. And those are very difficult conversations to have in the courtroom when that comes up. Going back to criminal procedure, the primary source for procedural law is our Bill of Rights. It incorporates beyond the Bill of Rights down to the 14th Amendment, but some of the amendments that matter the most to the court system and to law enforcement officers is, of course, the Fourth Amendment, which bars illegal searches. The Fourth Amendment is the one that requires us to go get a warrant, and there's plenty of case law out there based on the Fourth Amendment that tells us when and how we're to apply for those search warrants. The Fifth Amendment limits the admissibility of evidence and of confessions. We have to prove the source of that evidence and the relevance of that evidence to a case before it can ever be admitted. With confessions, here we're talking about Miranda, okay? A common misnomer with folks is that they believe that the minute handcuffs are put on a defendant, they should be read their Miranda warning. That's not the case. The only time that we have to give the Miranda warning is when we intend to directly question them about the events that took place. In the sheriff's office, we see this on a regular basis. Someone is being booked in, and we're asking them identification information, their name, their date of birth, their social security number, their address, their medical history, etc. And they get upset and they say, "But you didn't read me Miranda." None of that information has anything to do with the case that was being investigated. Now, if we go down the road and ask them questions specific to any actions that they took that brought them to the jail, we had better have read them Miranda first. We also don't have to read Miranda if these people are not in custody, and that is a legal challenge that happens on a regular basis. If we've not taken someone into custody, we're free to ask them any question that they want, and they're free to tell us to walk away from them and not respond to any of those questions. And we're not obligated to warn them at that point why we're asking that. Once they've been taken into custody, or it becomes apparent that they are going to be taken into custody, then we have an obligation to provide that warning. The Sixth Amendment guarantees the right to a trial. A trial is presumed to automatically occur unless the defendant waives his right to a trial. Anytime they're brought for their first appearance, for an arraignment, or even after a preliminary hearing, the court automatically sets a date for a trial because it's presumed that the defendant is going to act on their right to a trial until they say otherwise. Our Eighth Amendment applies in criminal procedure because it prevents excessive bail and it prevents cruel and unusual punishment from occurring. And I threw the 14th Amendment in here, not because it's a part of the Bill of Rights, but because it's the glue that requires this standard found in the Bill of Rights to be applied at every level of government. In other words, the 14th Amendment ensures that the Bill of Rights applies in municipal courts for traffic tickets, at the district court level for felonies and misdemeanors, at the appellate court levels, and even within the federal courts. You're entitled to every single one of these rights, regardless of the level of court that you're sitting in front of. When we talk about due process, we're still talking about procedural law. Okay, so this is constitutional protections and statutory protections that the entire system must follow. Predominantly, these are actions that the courts must take to ensure that a defendant's rights are as protected as they possibly can be. Every defendant has the right to know why they've been incarcerated in a county jail or what it is that they're being charged with or accused of doing. They have the right to formal hearings. In almost every circumstance where someone's been arrested, they will stand in front of a judge within at least 48 hours of being placed in the jail. Everyone has the right to counsel, whether it's the state who's paid for that or they have to go hire one on their own. We cannot refuse someone the right to an attorney or access to an attorney. At trial, they always have the ability to challenge witnesses and to challenge evidence. They're not required to testify on their own or not required to answer any questions that might incriminate themselves. Again, the Fifth Amendment there. They also have the ability to provide witnesses on their own. In many cases, we see character witnesses that are brought up on a regular basis, and this isn't unusual. They're entitled to a decision from either a jury or a judge that relies solely on the evidence that's presented and the testimony that's been given about the circumstances revolving the case and nothing else. Those decisions have to be made in writing. That's what's known as a journal entry. And then every defendant, regardless of the case or the court's jurisdiction, has the right to an appeal, as all the way up to the United States Supreme Court if those courts chose to move forward that far. Guys, that is the quick down and dirty of chapter 4 and the source of our laws, the substance of our laws, and where they come from. I look forward to your discussion post this week about the questions involved there. This also is the end of Module 1, so you have a quiz to take this week. The quiz incorporates questions from all 4 chapters, and so you need to make sure that you've reviewed those high points through the chapter as you go through. And it's simply set up alternating as multiple choice and true false questions related to those chapters, so that you've got the time to look through it. I've given you an hour to take it. I think that's more than plenty of time, but please make sure you get that in and submitted by the end of the week. And then the next time we speak, we will be into Module 2, kicking off with Chapter 5. Have a great week, everybody.